May it please, Lord. My Lord, you have filed an IA in item number 55. We are seeking implement in that matter. Would your Lordships kindly permit us to bring the IA, my Lord? 55. 55. That's High Court land matter, my Lord. We are the people who are staying behind. We have got to know only recently, my Lord.
Sir Chaudhary, I may tell you. We directed TC
Yes.
to give notice to those who are.
They have not given. We have made a categorical amendment in our IA.
I will show you the notice. I have myself seen it.
But my Lord, our only grievance is that the construction of that pathway in the form of a staircase, that will, my Lord, deny access to us. There is already about 12 feet road, and after Honorable High Court has left 5 feet, now it is 17 feet.
You look at the pleading independent instead of being instructed by software.
So what I'm praying is, my Lord, your Lordships kindly take our implement petition, if not today, on any other day, my Lord. We have filed it today, my Lord.
You have filed it today.
Yes, my
We'll take up at 2 o'clock.
My Lord.
We'll implement you as part.
Yes.
Then we'll grant you time. Also.
Yes, yes.
We are not in a hurry. We want to resolve this.
Correct, my Lord. My Lord, since we are the people who would be affected, we have our say, Lords will consider our part, my Lord.
That is what we are saying. We'll go as per the settlement which is already there since years.
My Lord.
I can't unsettle anything.
Yes. Because the moment, my Lord,
You come at 2 o'clock. We'll
my Lord, I'm deeply. May I please, Lordship, item number 39, my Lord. May I pray that you take up at 2 o'clock, my Lord. I have some, my Lord, actually morning only I have got the brief, my Lord.
So that main matter is already coming up on 8.
On 8 it is fixed, my Lord. So there is some urgency because the nomination is on 2nd, my Lord. That's why we filed an IA, my Lord.
We have seen that IA.
Yes, my Lord.
You can file nomination. Nothing else is going to happen.
No, but we are questioning the voters list, my Lord.
Maybe.
Because if the voter list is defective or
Mr. Counsel, you can. We'll have to hear the department also.
My Lord, my friend is there, my Lord.
I know that. You all are our friends also. Why do you run away? We know the issue.
My Lord.
Therefore, at the most, you may have to file this nomination. You are on 8th, we will consider.
Yes, my Lord. Correct.
Notice returnable on 8th.
Establishment.
You take instructor or file reply by 8th.
My Lord. I have already filed, my Lord.
So Lordship will take up on 8, my Lord.
We have issued notice in this today.
My Lord.
Establishment. In your IA.
In your IA. It has to be heard. We are conscious about
My
it.
Lord. My Lord. Obligement.
Wait, please, Your Lordship. My Lord, with the consent of the other side, my Lord, I beg to mention item number 41, my Lord. My Lord, we may be allowed some time, my Lord, to file an additional affidavit to bring up some documents, my Lord, before Your Lordship, my Lord.
You are for the petition.
I put a petitioner, my Lord. For it, my Lord. Oh, that's my Lord.
Item number 43, my Lord. I am making a mention on behalf of the respondent counsel, Mr. N.K. Borua and Ms. T. Dutta. Certain members of their family are hospitalized, my Lord. They're seeking an accommodation for the day. I have taken the consent of Mr. H.K. Das.
My Lord, Lordship has heard this matter earlier, my Lord. Your Lordship was supposed to pass order, but somehow the matter got delisted. Maybe take it up on Monday, my Lord. That is with regard to this industrial tribunal.
We know we had opened our mind that we may remand the process.
Remand back, yes, my Lord.
In fact, I may to tell you in my notes I have written remand in block at block.
Yes, my Lord. Your Lordship was supposed to pass the order.
When do you want, sir?
Monday, my Lord. If otherwise not convenient. They are agreed.
Monday.
Value.
May I please, Your Lord? I beg to mention item number 17 and connected matter is 18, my Lord. I have taken the consent of the other side, my Lord. In this case, my Lord, they have filed and my Lord written statement. You need to file a reply, my Lord, short reply, my Lord. One is,
What is the position of encroachment if this is?
my Lord, that for the encroachment that has been, my Lord, removed. And there is an order passed by the Supreme Court that I brought in record.
No,
But-
that Supreme Court record is there, order is there in our file.
My Lord, no encroachment in my, I am representing the, my Lord, respondents. In their area, there is no, my Lord, encroachment. In the order, it is stated, man.
When do you want?
My Lord, next week.
17, 18.
Are they are connected? Man?
Yes, my lord. Connected.
May I
Maybe
please your
I wish to
lordship?
mention item number 14, my lord. For adjourn for one week, my lord. On 14.
Next week. Yes,
Lordship, I
next
beg,
week, sir.
with the consent of the other side, lordship, I beg to mention item number 8, lordship. I'm for
Yes.
the respondent, lordship.
It may come after vacation, my lord.
The transfer matter.
Yes, my lord. Transfer, my lord, that person has already resigned from service, my lord.
Then what remains in this office?
Lordship, that has not been accepted, lordship. Resignation has not been
Not
accepted.
accepted, my lord.
No, maybe you may accept, may not accept, that is another aspect.
Yes, my
But
lord.
then the question of transfer would not survive at all.
My lord, let it come after in the next week, my lord.
Take instructions.
Yes, my lord.
Okay. May I
Current
please your
Advocate
lordship?
General was just here. You should have asked him. It should have been over today. Current Advocate General appears with your counsel.
Yes.
Then you should have asked him. He is here. It has virtually become academic. Tell us next week. Next. You don't brief the learned AG on the earlier day. This is difficult.
Yeah, please, your lordship. Lordship, with the concern of the other side, I beg to mention item number 10, lordship.
Yes.
Lordship, engaging counsel, Mr. R. Bora is out of station, lordship. Can the matter be taken up in the next week, lordship? Lordship. No, lordship, I'm appearing for the appellant, lordship.
Item 10.
Item 10, lordship. Lordship, in the cause list, at the senior advocate, Mr. K.P. Pathak, name is being reflected. He is no more engaged in this matter, lord.
There is a change of come.
Yes, lordship.
All parties are south.
Lordship.
All parties are south.
Yes, lordship.
Give him some date. Next.
May I please your lordship? With the consent of the other side, I beg to mention item 16.
Item.
16, lordship.
Yes. Yes.
This time may be given for filing of affidavit.
Mr. Das was to file affidavit. High Court was to file affidavit
Yes, sir.
at the request of Mr. U.K. Nair.
May I please, your lordship? With the consent of the other side, lordship, I beg to mention item number 15, lordship. Lordship, may taken up this matter next week, lordship.
Give some date, not next week.
15.
15. It is regarding that regulate.
Yes, lordship.
My lord, with the consent of the other side, I beg to mention item number 33, 34, and 35. In this cases, I am led by senior counsel, Mr. Dikanta Das, and he is out of station, my lord. I have taken the consent of the other side, my lord.
32.
33, 34, and 35, my lord.
What the notice is not served. Await notice.
My lord,
Notice is not served on the other
my
side.
lord, notice they have served copy, my lord. We are filing Okalatnama, my lord, in item number 33. In respect of item number 30 and 34 and 35, I am for the appealants, my lord.
At the request of Mr. January. Next. Yes.
I'm obliged. Please, Lordship. Lordship, I beg to mention item number 44, Lordship. Since the engaged counsel is out of station for medical grounds, Lordship, I pray for an adjournment and the matter will be listed after 4 weeks, Lordship.
January. Next.
On behalf of Mr. M. Chaudhary,
Next.
PJ Das.
May I please your lordship? I beg to mention for
Granted.
item number,
Lordship,
We will adjourn it.
Lordship.
may I please your lordship? I beg to mention for item number 53 of supplementary list, your lordship.
Yes.
The council is out of station, your lordship. I prayed for adjournment for 2 weeks, your lordship.
2 weeks. Yes, sir. You want to mention?
Yes, your
Tell us.
may please your lordship, my lord. Yesterday I have filed one writ appeal, my lord. My humble prayer, my lord. This writ appeal may kindly be listed on this coming Thursday or Friday, your lordship.
Monday.
The urgency is that your lordship that the NIT, we are not able to finalize the NIT. The NIT offer regarding the onboard catering service in the train was challenged.
Monday.
Monday, no, not Monday, your lordship. Tuesday or Wednesday? Tuesday.
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 Oblige, your lordship.
May it please you, your lordship. Lordship, I'd like to pray for listing of a withdrawal matter for tomorrow.
Tomorrow.
Much obliged.
May it be, your lordship. Lordship, with the consent of the other side, I beg to mention item number 45, my lord. We adjourn for that. Come out
45.
45. I'm for the appellant.
Next week.
My lord.
Imagine for 4 weeks.
No, no, no.
Next
It is compassionate appointment, isn't it?
compassionate appointment.
Next week.
Madam.
It
Deeply
is a
applied.
covered issue against you.
Yes,
Don't
sir.
run away.
Next week. Deeply.
Item number 1 of daily list for motion.
Here, please, Lordship, by way of this PIL, the petitioner, who is a public spirited person, has made allegation of irregularities, illegalities, and corruption. In the recruitment of total 170 posts in the department of.
We have already acted on the prayer of this petitioner.
You file your response.
You
File your response. Notice actionable after 1 week. Next,
Item number 2.
do you waive for the respondents?
Lordship,
Do you waive for the respondents?
we are for all the respondents. I'm for AFDC Lordship.
My lord, your lordship can hear me?
You wait, your turn will
Please,
come.
your lord.
Your turn will come, please. Wait. Pull out.
Item number 2.
My lord, this writ petition has been filed challenging the virus of the Karbi Anglong Land and Revenue Act 1953 and Karbi Anglong Land and Revenue 4th Amendment Act 1973. As ultra-virus,
Notice. Next,
oblige your lordship.
Item number 3 to 7.
and notice to learned advocate. Next,
The item number 3, my lords, I beg to appear on behalf of the petitioner.
3 to 7.
Yes, Lordship.
Uh,
This matter is relating to Matia Transit Camp Lordship,
Yes.
which is supposed to be.
Last time we had passed
Yes,
the
Lordship.
order.
Yes, Lordship, we have gone through it and there was a meeting of all the stakeholders. And we have already decided to bring 43 persons from the Office of the Inspector General of Prisons, Health Department, Server Sikta, DC Office Gwalpara and PWD buildings. All these 43 persons already attached, Lordship. We have also requested the SP Gwalpara to give a platoon for the security purpose. There are 6 watchtowers plus the security is required. From all these 5 departments, we have already received their no objection and they can be deployed immediately in a day. But regarding the SP's platoon supply, Lordship, he has shown some difficulty because majority of his platoon are in Gujarat for the election till 8.
But that will be over on 8.
8. So we can start it from 15th, Lordship. We have already procured everything, Lordship. Utensils, disease seat, everything.
You start before.
And that will be immediately from the local,
No,
whoever
you
are there in the detention camp.
Start before 15.
We'll do it, Lordship.
Mr. Uzefa would agree that in Gujarat, nothing is done after 15th of December.
After 6, nothing is actually counting is on 8th, Lord. But only thing that the transit will take some time. That is the reason 2-3 days time it will take.
They don't travel by train, Mr.
No, Lordship, these are the platoons.
Platoons, they travel by what?
Train, mostly train, Lordship.
Train. Mr. Emedi, let them, you must be aware
Very
about
well.
our last order.
Yes, ma'am. Yes.
In fact, I and my brother both had visited the site.
Well, I'm very grateful for the indulgence. I'm
Because
extremely
we were on a administrative meeting there, so we took the chance of, and we have made it clear in our order also, we have not kept it up the sleeves.
Lordship,
Because
please.
it is better to put it on record that the court has visited, because otherwise sometime it may be felt that why court went there. We were worried about it, therefore we have taken that opportunity of visiting. Called Mr. Mr. Uzefa Ahmadi, senior advocate assisted by so and so. For the petitioner. And Mr.
Only I think I would like to clarify one thing, Lordship. we have 6 detention centers.
Yes, yes.
Immediately, the Gwalpara will be stationed
Yes,
there.
yes, we are
And
conscious.
phase
about it.
wise, Lordship, by 31st
Learned
of March.
Advocate General, we don't say that you start all within.
Lordship,
5 days. We are
Lordship.
not recording anything.
Because in the meantime, we are going for a regular recruitment also. 117 persons
You
are
will have
actually
to.
required.
It's a huge campus.
Lordship has
It-
seen it
I've
definitely.
seen it.
Infrastructure is very good. Only the manpower was the problem.
It is really good,
Lordship,
really good.
Lord.
If
Obliged,
if you compare it with the Guwahati Central Jail, which I and Mr. Nath have
Lordship.
visited, it is
Lord,
can be compared.
Lordship.
Just one aspect, Manoj, that I'd like to flag, Manoj, for your lordship's kind consideration.
Yes.
I'm extremely grateful for the indulgence. There's only one or two aspects that we wish to address your lordships on whenever convenient to your lordship.
Mr.
And that
Revati,
is
that you can, but let us first achieve something on the issue of starting of the transit camp.
as your lordship.
Uh.
As your lordship. I'm
Lord
grateful.
Mr. Joseph Ahmadi, Learned Senior Advocate for the petitioner, and Mr. T. Sakia, Learned Advocate General Assam, assisted by Mr. T. Nath. Pursuant to the order dated 17th of November 2022. The state government has taken conscious decision to see that the Matia transit camp is made operational. And Advocate General states that the state government would require some more time to deploy the necessary security security personnel and fixed time adjourned to 20th December.
Lord.
Next.
Highly obliged.
Lordship, please.
20 December.
Lord.
I'm not keeping Friday because of you.
I'm extremely grateful.
On Friday or Monday.
I'm
Next.
extremely grateful.
Matter number 9.
May I praise your lordship? Your lordship, I need another 4 weeks time to file my affidavit in reply. The affidavit in reply is already almost prepared.
At the request of next.
Obliged.
Matter number 11.
Well, I think the matter will have to be hard at the admission stage, my lord.
Lordship, today we have.
They have filed their affidavit today, my lord.
When do you want?
Any date convenient to lordship, my lord.
You tell me the date. I don't want to learn now limitation on the eve of my meeting office. Different than what I have studied in law. If any way can be found out, talk to.
I'll try my best, my lord. I've got some decision.
No. For that we can't have any doubt.
Hey, my lord, January, my lord. Deputy.
You in a lighter vein, your name is one of the name of the Vishnu Bhagwan. Are you aware about it?
No, my lord, I couldn't follow, my lord.
Your name, first name, is one of the name of the Vishnu Bhagwan.
Yes.
Therefore, you are bound to show me something. Next. Next.
Matter number 12.
In this case, my lord, in the habeas corpus case, the state is supposed to file an affidavit, my lord.
Yes, Mr. Nath. Mr. Majmudar is there.
We'll be relying on the affidavit that we filed before the honorable single judgment. Lordship, I fix a date of hearing, possibly no affidavit from our side, fresh affidavit is used. No fresh ground, no fresh facts are required to be brought in. Let the matter be fixed for a disposal or any date you lordship please.
Read para 29 of the judgment.
My lord.
But
अच्छा ठीक है पैरा 29 मतलब
Yes.
page 97 may I read it out a perusal of
No,
the
you need not read.
minor
See, 9, 10, para 34.
minor
The aforesaid opinion of advisory report is, it is noticed was rendered within 12 weeks, 6 days, which is marginally beyond 11 weeks. Para 34.
para 31 I'm sorry yes
Two aspects are there.
minor
Whatever what council wants to argue, we don't know. But para 29 and 30.
29 and 34
Yes.
about disposal of the representation minor
No, first is representation,
yes
and the second is advisory board. Because one of the ground was that 9C is breached. It was not decided within 11 weeks. It was decided within 12 weeks and 6 days. Now the learned single judge says that it is marginal. In Article 22(5), marginal is not to be seen. Even if it is 1 day is out.
has to be explained
Probably
then we'll file an affidavit on these two aspects
probably you are covered by a recent Supreme Court judgment.
minor deep there
I don't know what you want to argue, but
minor
But can it be, my lord, next week, my lord? Well, he is already behind the bar for more than 9 months, my lord.
no, that also we have seen that how many months are left. Otherwise, we would have finished it.
But all the cases I got bail, my lord. But can it be next
So
week,
in a lighter vein, I always say
my lord?
this is reverse of surface matter. Here state would go slow, there the borrowers would go slow. It is resultant is effect is the same.
My lord.
At the request of Mr. Majmudar Lanet, additional advocate general, assisted by Mr. T. Nath. Time is granted for the state to file the affidavit. When do you want, Mr. Majmudar?
My lord, can it be on 8th, my lord, if possible, my lord? Next week, my lord.
You come from outside or you are here?
No, I'm from here, my lord.
I'll leave it to Lord
Let it be 12.
8
12.
but 12 I've got small personal difficulty
13.
30
I'm obliged.
8, my brother may have some difficulty, therefore I'm not keeping.
if your lordship is not inconvenient, could it be 14th or the next day 14th and I've got some personal family program somewhere
14.
14th
Item number 13
Because virtually it would be for final hearing.
yes sir. Before that we'll file
14th that I'm on account, 15th.
correct
Well, on 15th, my lord, 14th I have some. 15th, my lord. I'm sorry, 15th. my lord.
I don't mind keeping it in January also. You are in the
15th madam.
15th.
Yes.
Yes.
item number 13
May it please your lordship.
Yes.
Lordship, here of India has challenged the judgment and order of the learned single judge lordship, starts from page 18, lordship.
Will it you notice? You waive for the other side?
Lordship,
I'm appearing for the other side.
here's an,
I was the petitioner in the petition.
I also lordship for stay of the
What stay? Which is the date of the order?
lordship, we had passed an order of dismissal from service. The learned, honorable single judge has remanded the matter back to the authorities for deciding it afresh by taking a lenient view for any other punishment, then removal from service, lordship.
We are conscious about.
Lordship.
Notice.
I'm deeply obliged here.
Next.
item number 53 of supplementary list.
So 53, somebody mentioned it.
Item number 54
Appeal to there. No, here to Made future lordships. My lord, your lordship gave us liberty to approach the single judge, learned single judge. We approached the learned single judge. Learned single judge merely, my lord, extended the time. My lord, our only case is, my lord, if your lordship would kindly have the Assam land revenue regulation, my lord. এখন কিতাপ দিয়ক না। Land revenue regulation.
But Mr. Chaudhary,
My lord,
we were thinking on another plane. You pardon us for
my lord.
the litigation which has continued up till now. You came at the interim stage, you went there, now you have come back. Ultimately oversurround a show cause notice.
Yes,
No eviction order is passed.
not yet.
Now, secondly, even if
No, my lord, eviction order is not passed, but my lord, time has been given whereby we are supposed to, my lord, vacate.
bear with us for a moment.
Yeah.
Therefore, it is at least show cause notice stage. Now, two aspects in that. You have a right to challenge the show cause notice. At the highest, it is not without jurisdiction. Some authority will have to be given an opportunity to adjudicate whether there is a settlement in your favor or your predecessor, or you are an encroacher. Now, that authority, the authority which has issued a show cause notice. For example, after say, hearing you and all that gamut, passes an order of eviction. That is appealable under
Land revenue regulation.
land revenue regulation. Therefore, at this stage, 153 people,
Families, my lord.
family. Therefore, no, today there is no order. And all the, on the contrary,
But if your lordship clarifies that, we can approach the authority, but that is not the position.
no,
my
no,
lord.
no, no. What we want to clarify is this.
Yes.
That show cause notice will be given.
Hmm.
Appropriate show cause notice. As per whether it is 3 days or 7 days, we don't want to go into the legality or, but it is a discretion which has been shown in your favor. We only say that a proper show cause notice should be given.
Hmm.
You should be given an opportunity to file reply.
Yes.
You should be given an opportunity of being heard, and then an appropriate order be passed.
Yes.
That is the
Because, my lord, no determination, because we'll put our perspective, authority will decide. If we agree, we'll either go to appeal or come here.
that is in fact still on a single judge has provided, but we'll expand that
Yes.
while not entertaining.
Actually, my lord, because the proceeding was going on before this honorable court, therefore authority issued those orders, thereby no adjudication straight away. We have been asked to vacate.
Now, therefore,
Ah.
sometimes the
No, my lord, what has fallen
No,
from the
I'll
lordship,
tell you,
we are agreeable, my lord.
Mr. Chaudhary, the format of the show cause notice is such that now this is done long back. It can be termed that it's an eviction order itself. Really, it is a show cause notice.
No, lordship is correct, because first some determination has to be done by the primary authority,
Ah.
which has not been done in this case.
These are not title suits,
Yes,
because your limitation to claim title is also evaporated.
my lord,
If we
there,
read-
my lord, there I am not,
No, I am not joining issue on that.
Yes, yes.
On your own pleading.
yes.
But
My lord-
it's a major issue.
Huh.
Which
In fact, my lord, there is a full bench decision of our High Court, my lord, on 154A. My lord, when a bona fide claim of right is involved, then this summary proceeding should not be invoked. Then, my lord, civil suit is maintainable. That because there is a bar of civil suit, and those are aspects we'll all raise before the authority. Let authority take a call. Until then, my lord, some protection should be given.
No, but there is no order in against you. Where is the question of
No,
protection?
since your lordship is
When we are providing all this,
Yes.
naturally nobody would
Yes,
dare to do it.
yes, yes. Oh, I don't know. Only thing is, my lord, the notice which you have put to challenge, till the authority takes a call, they will not give effect to that notice.
You read the paragraph 70.
No, yes, I have read.
However, in view of the 3 days notice, eviction notice are set aside.
No, but my lord, true.
So today there is no eviction notice.
No, but time has been extended, my lord. Instead of 7 days, it has been made 3 weeks.
That is what we are saying.
Yes,
That proposed notice.
Ah.
We are saying that there is nothing wrong with the order.
yes.
The authority will give them an opportunity to of hearing and then
Ah.
pass an order.
Ah.
We are extending what learned single judges.
My
We
lord.
are not entertaining your appeal at all.
Accordingly, notices are set aside only to the extent that the 3 days time had been given to the petitioners to vacate that the court direct responded with another 3 weeks time.
We have seen that.
Yes, only that part lordship will have to modify.
No, this court direct responded will give another 3 weeks time
Ah.
from today to vacate the lands they are illegally occupying.
My lord, that
In
finding
terms
also, my lord, should be ignored by the authority while deciding.
Therefore, on one end, the learned single judge what is the notice, and on the other end, it is said that we are conscious about it. Therefore, you give these dumbbells to learned government advocate. Let them also have. We are not passing any order today.
Well,
You will be appearing. You have the paper.
Lordship, in item number today, item number 21, you know, I have filed the affidavit. In that affidavit, your Lordship, the district administration has already chalked out the eviction plan and the dates regarding the 3 circles where encroachment is there mainly.
That is what.
Dates have been final.
That is a different issue. This is we are talking about this matter. Serial number 53. Do you have the paper?
No, but
Then why are you? This is revenue department. We know that you are a counsel for revenue department. Therefore, take copy from.
no, we have given copy.
No,
my lord, they're holding the
I
copy.
have the writ appeal copy, but instruction documents I don't have.
Look at it and tell us next week. Called Mr. K. Chaudhary, a senior advocate, assisted by government. You can consult learned advocate general about it.
My lord, 3 weeks time can expire. My lord, this 3 weeks will expire tomorrow, my lord.
Who is going to come 3 weeks? If you take 21 days to file the petition, naturally government will also take some time. Who is going to vacate it?
No, my lord, only thing is, my lord, the tomorrow, my lord, the damage will be done.
Mr. Chaudhary, this habit of coming at the eve of the is
No, my lord.
you know I had confessed in the open court that I am very slow in granting
No,
interest.
true, my lord, but here lordship will some protection.
And-
They will,
and you-
till they obtain the inspection, they will not precipitate the matter.
They will do nothing.
No, my lord, they will do, my lord.
This is being discussed in open court. Why do you worry?
No, my lord, they are,
Yes,
because
I
they,
ask your officers not to do any, not to precipitate the matter. Learned Advocate General, you may not appear, but
I will instruct.
please
Yes, I'll communicate.
have a
Yes.
conference with the council.
Yes, 1 week's time, they did not do anything. That can be.
till next year.
We are keeping it next
My lord.
Tuesday. Otherwise, why we are saying that also you are listening to what we are saying. This type of matters unnecessarily, they remain here for years together and the encroachment continue.
Yes, lordship. And if there's a stay order on writing,
Ah.
lordship, it will continue.
And they are entitled to proper notice. All that we want to say that
Yes.
give a fresh notice.
Ah.
And or we may provide that this notice is also part of the notice.
Or lordship may close it with that observation.
Give them hearing
Ah.
and pass an order and then you will
Lordship.
have to.
Lordship.
But we are not in a hurry. Let it be done next Tuesday.
Lordship.
My lord.
Mr. Chaudhary, your papers itself require some settlement.
Hello, what to do, my lord? It's so many
Maybe,
pages.
maybe in your chamber also. Which is the serial number?
My lord, item number 21 to 21 is also connected, my lord. The PIL, that is the original PIL. So it may also come next week, my lord.
It will come together.
Yes. Deeply applied.
Next.
What are we today?
But in 21, my lord, there is an stay order in my favor, my lord.
I know that. I know that will continue. We are conscious about it, therefore we are taking this. Otherwise, this will never see light of the day. If you are encroachers, you will continue for years together. And instead of the authority deciding under the revenue laws, you want read
My
court
lord,
to decide.
in my case, my lord,
Whatever it may be, you
petitioners.
reserve your right.
petitioners in Chandrapur Circle, my lord.
You reserve your right till
My
Tuesday.
lord, we are in the Pataland, my lord.
Next
We are not
Tuesday, interim
encroachers.
relief to continue in serial number 21.
Made please, Lordship, in respect to item number 19, Lordship, SLP is still pending before the effect for Lordship.
Still pending.
Lordship.
Next, same order. Give it notice.
Yeah, please, Your Lordship.
Notice is not served.
My lord, on 21st 10,
Notice
Your
is not
Lordship.
served,
we have taken the step, my lord.
but it is not served.
There's no report.
Next,
All right, my lord, obliged.
give it notice.
Item number 22.
Yeah.
Hey, give it is- Union of India. right? Who appears for the Union of India?
I am here for the Union of India, my lord. We have received the instruction regarding utilization certificate, my lord. Utilization of the sanctioned amount, my
You
lord.
have to file affidavit.
Yes, my lord.
File affidavit,
Yes, ma'am.
Miss R. Prabha. R. P. Rabha. Huh?
Hey, Gayan.
Yeah, guy. Every time there is a change in council,
No, I'm my lord, CG Central Command Council.
last time somebody else appeared for Union of India. Miss A. and Central Government Council. Sixth time to file affidavit. Adjourn to 12th of December,
My lord, can it be, my lord, before 12 or after 15, my lord?
19th.
Yes,
Leave
ma'am.
Item number 23.
Let's meet up with. What have you thought of? Any possibility?
No, my lord.
No possibility. As per the order dated 10/11/2022, the learned councils appearing for the parties were requested to explore further possibility of a compromise. Mr. Das learned counsel, as well as appearing for the appellant, as well as Mr. P. Kataki, and counsel for the respondent, states that the parties are not in a position to explore any solution. Hence, the matter be listed for its final hearing in the week beginning from 17th of January. Next,
Item number 24.
This is regarding my lord, the brick lane which was set up in the international norms, my lord. Let this come up for admission hearing or let it be admitted or fixed for hearing, my lord.
You want to file a reply?
No, my lord, the pleadings are complete on our part, my lord. They wanted to file a reply on the last occasion, they did not renew the prayer, my lord.
Mr. S. Hussain took time last time.
Yes, my lord. Thereafter, prayer was not renewed on the last.
I prayed for fixing it for admission, your lordship.
We'll admit it. What else?
Lordship, it can be fixed for admission.
No, we'll admit it now. It is pending since 2 years.
Lordship.
Admit for hearing.
But can I pray for a date for hearing?
That will be granted.
Item number 25.
To be listed on 8th February 2020. Next. Yes, 25.
I'm private respondent, my lord. The read petition, my lord.
Instead, item number 25.
25, my lord.
Who appears for the government?
Mr. Borpuzar was appeared on the. Mr. Borpuzar was appeared on the last occasion, my lord.
We'll pass it over. Is he available or is not available? We'll pass it over.
It will be taken up at 2 o'clock.
We'll pass it over.
Item number 26.
Yes, sir.
Well, in multiple level 7, my lord, we had made an attempt to come to a settlement through mediation, my lord, but that did not materialize. Now I want to file affidavit in opposition in that case, my lord. Another case, my lord, the petitioners filed a petition under section 24 of Indian Marriage Act claiming litigation cost, my lord, that is registered as IA 2237. Now, my lord, the petitioner here in this IA, she is serving as a Anganwadi worker, my lord, and she earns only 400, about 400. And her husband has been paying her maintenance allowance only 2,000 rupees as maintenance to herself and her son. His son is now in class 10, my lord. Now, I pray, my lordship, that some litigation cost may be given. The husband was serving, my lord, as a lecturer. Now he has retired. He's a,
Do you want to file any opposition?
We have filed an opposition, my lord. And I also feel that 2,000 is a bit less. Sir.
Bit less? It is very less.
But so, my lord, if lordship.
So what is the pension that you get?
29,000.
29,000. Then we'll increase it to 15,000.
But if I may pray, my lord, can he pay around 8,000?
Minimum 10,000. If you divide 29,000 into 3, it will be 10,000 each.
In that case, my lord, if the lordship may call him, my lord, because my fairly submitting, I also feel that it is less. So if lordship may call him once, my lord, then the person, my person confess.
You are appearing. Why should we call him? If mediation, you don't want to agree and you want to agree in open court.
If I may fairly submit, 8,000 will suffice, my lord.
Then you leave it to us. We will. 2,000 is nothing.
My lord, that I also agree. My
Even under MSCT, the housewife gets is considered to be 5,000.
lord.
Should we pass that order, or you want to file opposition?
No, I have already filed opposition, my lord. But I'm just submitting on the fact that 2,000 is less, my lord.
There is no opposition in the IA.
I have filed, my lord.
The IA.
Yes, my lord. On 22/11.
In the IA, they have denied that they have got landed property and adult property, but we have made documents of landed property. We shall submit it along with the affidavit in opposition, my lord.
There is no IA in this. IMA.
We have filed it on 22nd November, my lord.
Yes. The registry has taken it along with the main appeal. That's the difficult. Then we'll consider your reply and opposition and pass the appropriate order.
10,000, my lord, if
10,000. 10,000. IA allowed.
yes, my lord.
We'll pass the order in the chamber.
But my lord, my
Main
objection may be noted, my lord.
Huh? Yes, yes, yes.
My objection may be noted.
Main matter to be listed for final hearing.
After the affiliate
In the
member,
week beginning from 17th of January. Next. IA allowed. Next.
Item number 27.
In this case, a clarification was sought regarding who is the higher authority in the affidavit filed by the PWD lordship. The higher authority according to the PWD is this department. Earlier it was Health and Family, now it is called Medical Education and Research Department, Government of Assam. So they are the sanctioning authority and it is their project. PWD is just executing the work. So in respect of that lordship, there is no doubt that this particular department is the higher authority and they are supposed to take the call. Now, they have also taken the call regarding having a separate arrangement of 1 meter wide gate to access the Nopukuri pond at Borigaon, Nolbari for local public. And before giving the final clearance, they wanted to take an opinion from the Deputy Commissioner, and to the Deputy Commissioner also, they have written a letter on yesterday. So seeking 1 week's time to give get the clearance from the Deputy Commissioner.
So we defer it for a few days.
Lordship.
Adjourn to 13th of December.
Lordship, in the meantime, everything will be clear.
So we can close this procedure.
Yes, Lord.
Next. 13th of December.
Item number 28.
At the joint request. Serial number? Yes.
Please, your lordship. See, we have filed the amended petition today, lordship. It may be listed for admission hearing any date.
Monday. The matter be listed with amended petition on Monday. That is 5/8. Next.
Item number 29.
Please, your lordship. Your lordship, we need some more time to file steps. To take steps. We are unable to get the appropriate access to it.
Next week. Next.
Item number 30.
Wait, please, lordship. My lord, I clearly understand that at this stage, whatever observations are there against me, well, I have some limitations to go into it. But if my lord would permit me, I would like to indicate a few things. But basically, there are 3 allegations against me. 1, 2, and 3. 3 allegations against me. Now, the inquiry officer's report on these 3 and the view of the higher authority on that would be germane so far as addressing these 3 issues are concerned. May I invite my lord's attention to page 77. That's the inquiry officer's report, 15 to 2010. For the reason,
Are we appellate authority?
No. For the reason.
No. Tell us that first. Are we appellate authority that we have to look to the inquiry report?
Not at all.
Then?
For the reason that since the findings against me.
But that we can't look into it.
I am not even on that matter. I agree to that. I bow down to that. Now, my service is gone.
What is the allegation proved against you?
My lord.
What is the allegation that is proved against you?
3 things were there. First thing, the first and the foremost was that I had not given the pre-sanction, the loan letters. And the inquiry officer report is that the complainants had themselves signed and taken it out. Invariably, that can be culminated to the word lie. They were lying. This is the fact-finding fact, my lord.
Good. Pass on this judgment to you. Have a look at this judgment.
Lordship.
There are 2 or 3 more, but I am not troubling.
My lord, lordship.
We have taken trouble of taking out judgment.
My lord. This was, if I recall correctly, the case of a postal assistant who had defrauded amount and subsequently
We are not on fact.
to subsequent deposited.
We are not on fact. We are on the ratio laid down by the Supreme.
My lord. It said that paragraph number 9, merely because the respondent employee had worked for 39 years, and in those years there was no punishment imposed, and or that he voluntarily deposited the defrauded amount along with the penal interest, and therefore he was no loss to the government department, cannot be a ground to interfere with the order of punishment imposed by the disciplinary authority and substitute the same from removal to that of compulsory retirement. Neither the tribunal nor the High Court have, in fact, considered the nature and gravity of the misconduct committed by the delinquent officer. Therefore, both the tribunal as well as the High Court have exceeded the jurisdiction in interfering with the quantum of punishment imposed by the disciplinary authority. Taken with us.
Now here, you have not even denied that you are in business of verbal life.
On a parallel submission.
And we are not here as an appellate authority to look at the aspect that this is properly dealt with or not. We are not appellate authority.
I take everything we got.
Yeah.
Page 80, a recording by an inquiry officer appointed under a law to carry out a procedure substantiated by law. May I invite my lord's attention to page 80 for a moment, 3 lines and no more. That's the third allegation. It is also alleged that you forced the above 5 customers who had availed housing loans sanctioned by you to part with rupees 86,000 each for buying Herbalife products and join membership of Herbalife for procuring their products on an ongoing basis. Allegation. The finding on the extreme right hand column. The allegation that the charge sheeted officer had recovered 86,000 per head from the complainants as written in the joint complaints letter dated 12/3/08 who do not be established due to non-availability of documentary evidence and eyewitness. The intersect community liability, as pointed out by defense, has also prevailed sufficient reason for the room for the complaint. I'm not on this library part, my lord. Since it is not substantiated by record, it does not surface for consideration at all. The disciplinary authority having taken a view contrary, the reasonings at page 71 have to match. May I invite my lord's attention to page 71 for a moment there. The difference has to be based on a reason, my lord. That's what I'm on. Agreed. There was some allegation 2 years later that after the loan was sanctioned. Agreed. The allegations on the face of it warrants an inquiry. Done. Inquiry. Procedural niceties met. Now the officer, so appointed under the law, says there is nothing on record against me. But the disciplinary authority differs. On what premise? That is precisely the question. If I may permit on page 71, may I read that part?
Therefore, you are arguing the appeal.
I am not even arguing.
Then what are you doing,
My
Mr.?
lordship may take a lenient view.
Why should we take any lenient view? When did you think when you were occupying your office?
On the 3 grounds.
Then even if it is 1 ground, we are not concerned with it. There is no lack of procedure. You were heard. Even
I was heard.
Your review petition was also considered.
Everything done.
Personal hearing given.
But though the findings reached.
We can't touch the findings, sir. We are not here to evaluate the evidence. Again.
Would it in this entire would it warrant a removal from service, my lord? Whether lordship may take a lenient view from that matter, even if lordship is taking a risk on that. But unless there are things on record to hold against me, I must be before a court of law to address that issue.
This is later judgment.
My lord.
There are 3 judgments. ये भी दे दो.
This is possibly of the constable, my lord, who was keeping
We are
on
not
duty
on facts. We are on
duty.
ratio which is laid down.
Ratio, my lord. Then out paragraph 9 would be
You are a
quantum of punishment.
giant service lawyer. Therefore, you go to facts. We don't want.
May I
You are an expert. We are not an expert. We are only finding out the judgment.
In the present case,
No, don't read it. We have read.
the quantum of punishment,
This is for your information.
quantum of punishment
You may not feel that
on that discussion, my lord.
court relied upon the
Absolutely.
judgment without showing it to you. Therefore, we are showing it to you.
My lord, whether lordship would exercise that discretion in this case, whether I have made out a case, my lord.
That is what.
That is what.
Otherwise, you can say that.
Otherwise, my lord, I leave it to lordship. Dismissal from service too long, too harsh for this. Disproportionate.
Your urban life is still, business is going on?
I have no contact with the clients. No contact with the client.
You give back those judgments.
Well,
It is for our personal use. But it is our duty to show
My
it to
lordship,
you. If it comes in judgment, then you may feel that court has relied upon the judgment.
I'd gone through judgments earlier.
It is meant for respondent advocates, not petitioners.
I'm not-
advocates. If you want to go through it, my brother says you can go through
Very
the.
well. May I have it after some time, 2 weeks? So we can have something to compare. If lordship permits.
Doesn't require 2 weeks to go.
I understand. But
In fact, we may tell you. Yesterday, when we were discussing our list, my opinion was that nobody will appear in this matter and time will be short, but I proved wrong. You have come, now we will not adjourn it for 2 weeks.
Tomorrow,
Not tomorrow, not in a hurry at all.
lordship. Advise me. Wait,
We'll give you some date,
lordship.
7th.
Seven.
Next.
Advise me.
Number 31.
Well, I have on behalf of the respondent of 7, 8, 9, 10, private respondent. For the private respondent, other than 7 and 15, your lordship.
You have to file some reply.
Lordship, today I am going to file your lordship.
File it.
And
Interim relief to continue.
matter has been settled amicably.
Huh?
The matter has been settled amicably, and in this regard, I am going to file the ATV.
You have settled the issue.
Yes,
Not-
lordship.
Huh?
Now,
Yes.
my lord, the private respondent, my lord, they have agreed, my lord, they will not pursue the matter, my lord. Because
Then
they
what survives in the appeal?
lost it. They learned it, my lord, single judge, my lord, directed to hold the meeting. In terms of a notification, my lord, 28/4, my lord. So now, my lord, to resolve that, they will not pursue the matter, no meeting will be held.
For the sake of the panchayat, your lordship.
Monday.
Lost.
You bring your affidavit.
Interim relief to continue at the joint request. It's for 2 5 8. Next,
Number 32.
await notice.
So, my lord, in this case, substitute is voided on the respondents.
That is what we have stated. Await notice. Give some date. Next,
Number 36.
await notice.
Number 37.
Same thing. Await notice.
Maybe the lordship.
Await notice. 36, await notice. Other side is not here.
It's 36, I am appearing.
You are appearing for?
Opposite party, white cloth.
Allow. Give it to us. What is his name? Who is appearing? Sumir Lokur. Will restore the applicant.
Lordship.
Heard Mr. S. Nath
Yes, my lord.
for the applicant and Mr. S. Agrawal for the respondent. By an order dated 3/03/2022, the appeal came to be dismissed for non-prosecution. Considering the averments made in the application, the application deserves to be restored back to file. The appeal be listed for further order on 12th of December. Next,
Number 37.
await service here.
I appeal for the private respondent number 10.
All are not served, so let it be served.
Lordship will take the private respondent counsel, sir, appeal, I will serve him, lordship. The rest I will take that.
steps are already taken.
Yes, Lord, steps are.
You have to await for the notice. Await notice. Next.
Much
Item number 38.
In this case, there was a direction to obtain instructions during that period when she was working and not working, Lordship. We have received the information, Lordship. I would like to file a short affidavit giving the dates during which time she actually worked and during which time she was not working.
Old Mr. P. Satyal and Advocate General assisted by P. Kaushik for the Education Department. And Mr. P. D. Das, Learned Senior Advocate assisted by Ms. R. Teta for respond number 1. At the request of Learned Advocate General, when do you want?
In the second week of December, Lordship.
Second week, my lord, will not be there. My lord. That will be first week of December. One page, my lord, I have already shown a page that in contempt petition, it is already mentioned how long we are working. I have
12th
shown
of December, Lordship.
Are you available on 12th?
My lord, before that. my lord.
9th of
Right.
December.
9th.
9th.
Interim leave to continue till then. Next.
Item number 40.
Yes.
Lordship, in this case, we had a meeting with this committee members, Lordship, and they have also started the process of whatever Lordship has expressed the other day regarding time restrictions. They are working on it. And last week, Lordship, all the senior officials were in Delhi, and today also they are all in Silchar. So I'm praying for 1 week's time so that they can take a call regarding the restriction in Thanapara as well as in Amingaon.
Next
So-
week. Next week.
Yes, and so for the other part regarding a bias terminal in Amingaon, Lordship, that thing is also being worked out,
Next week.
Lordship.
Lordship, from 13 to 17, I have this mediation training. So Lordship, after that, I won't be there on Tuesday, from Tuesday to Saturday.
No, we are saying next week.
Next week.
Week beginning from 5th.
Oh, 5th. Yes, Lord. Fine. Yes. Hello, guys.
Highly obliged.
It will be 6th of December.
Yes, Lord. I'll be.
Item number 42.
This matter will require long, full-length hearing, Lordship. This
42?
নিত্যানন্দ সরকার কোনটা? এই পুরুলিয়ান ডক্টর হয় জানো? Salary. Yes, salary, Lordship. Because there is lot of facts which Lordship will have to be apprised.
So, Learned Advocate General, we were thinking of an aspect.
Lord.
That the effect of it can be given from the date on which they were regularized.
That is what we are also saying. And they are getting the amount. From 2015, after honorable court's order, they were regularized and they were getting regular salary. Now they want from 2005 or 4 till 2014, during which time there was no post and there was no appointment. If they agree to that, I can stay to a concede, and they are getting it, Lordship. Whatever has fallen from Lordship's mouth now.
Then we will hear you because they may agree, may not agree.
They may not agree, Lordship.
You want it today or you want some day?
Some other day, Lordship. It will consume 2-3 hours, Lordship.
Next. No, it can't take 2-3 hours. You select the date. It will not take more time. How often?
Then let it be on.
My submission is very limited.
Ah.
My submission is very limited. Even going by the law laid down by the Honorable Apex Court, my lord. I am entitled.
Take date of your choice. Learned
Yes, Lordship. 13th of December.
13.
Highly obliged. Deeply obliged.
Item number 46.
Affidavit is a.
Made, please, Lord. Lordship, this matter relates to removal of a Gaon Panchayat president, your Lordship.
So some affidavit was called for last time. Mr. K. Kanwar was to file affidavit.
I'm appearing for the penalty, my lord. One affidavit has been already filed, my lord.
No, last time you took time because I don't know how this matter has been listed because it was to come up in September. Now it has come abruptly.
My lord.
The records were given back to enable you to file an
Affidavit.
On 26 September 2022, we have filed one affidavit, my lord. No, pursuant to that, there is the order, my lord. Order is 12th of September. My lord, my lord, actually, in this case, the senior Senate council case board is appearing, my lord. He is, because of the medical emergency, he is not coming to the court, my lord.
Because we had given back the record to see that the affidavit comes. That affidavit has not come.
My lord, may grant.
File affidavit as per the earlier order.
My lord,
Mr. To comply with the order dated 12th September 2022. It's done to January next.
Highly obliged.
The number 47 to 49.
Hmm? Do you have the from the any? Yes,
My lord, in this case, my lord, I am challenging the impugned judgment, my lord, single judge, my lord, on the ground that, my lord, in the impugned judgment, the learned single judge has failed to appreciate the fact that an executive authority cannot override the statutory provision of the act enacted by the parliament.
yes,
But, may I, my lord, draw your lordships to the background fact of the case, my lord. My lord, an advertisement was issued, which you'll find that at page 28, for filling up the post of principal,
see, the question would be ultimately
my lord,
that when they obtained PhD degree,
my lord.
whether that institution was recognized or not.
No. In respect of 6 and 7, no. Respect number 6 and 7, no. And in respect of 8, my lord, it obtained the, my lord, recognition from the NCT, but his degree was in violation of the service rule, my lord.
No, that you can't argue that.
My lord.
You can argue that it,
And my
it
lord,
was
he is also not
invalid.
he is also not interested in contesting the present, my lord, selection process as he has been selected in another school, my lord. He is also not interested in.
That does not mean that we can decide anything, whether contest or no contest.
Well, I will.
Because there is a finding at paragraph 40 of the judgment. As a result of the discussions above in connection with writ petition civil number so and so, the court does not find this to be a fit case for holding that the concerned institute offering BA degree had no recognition for the relevant years when the respondent number 6 to 8 had conferred with had been conferred with BA degree. Resultantly, it is not a fit case. That therefore 6, 7, and 8 were invalid. This is a finding of fact.
Vale.
So we will have to first go to that aspect.
Yes, my lord.
That when did they obtain? Who appears for 6 and 7?
I'm 7.
Who appears for 6? 6. Huh? Now, when did you obtain a BA degree?
I obtained my in the year 1995. But I am prior to having of that.
6 and 7.
My parents from for NCT.
I am for 5 years.
He has not come to the court.
Lordship, just few minutes back, Lordship, Lordship, perhaps our junior Lordship called me. So perhaps due to some problem, he might not be here. Lordship, I am for respondent number 5 NCT.
When were you recognized?
Lordship, as per records, Lordship, they applied on Lordship Silchar College of Education, Lordship, they submitted their application for recognition on 25/3/1997. Sorry, 23/5/1997. Lord. Thereafter, Lordship, the process was going on, and initially they were allowed to continue their admission, Lordship, and till 2001, Lordship, they have provisional recognition.
But these people have passed when provisional recognition was there.
Yes, Lordship, provisional recognition. Till 2001, Lordship, provisional recognition was there.
While provisional recognition was for the session 99-2000. It starts from 99-2000.
No, that you see, you are not the custodian of the original record.
No, my lord. It is his record, my lord.
Therefore, we will ask him.
So, Lordship, as per
You are a dog in the manger. We know that. Therefore, why should we rely upon you? You want to ruin somebody as you have not been flourished, as you have not flourished. It is just like that. You show us from some record that when these 3, 6, 7, and 8 respondents.
I am only with regards to 6, Lordship, regarding Silchar College of Education, Lordship. Lordship, I am having records, Lordship. If your Lordship peruse it.
No, who appears for the other respondent?
No, Lordship. Other respondents, my learned friend will appear. In the
Then we'll defer it. Because this we will have to first verify and then go ahead with the matter.
Every time it is getting different.
I know that.
due
That
to
is why
absence
by
of
now
account.
also. We'll keep it next week. Let us see. Next Tuesday. Next.
Item number 50. Even the compilation of the judgment on which I will be relying on, and along with the written argument, my lord. Let me keep it with the file, my lord, or
You keep it with you. 50.
Right.
Yes, Pathak is probably not.
Please, your Lordship. Lordship, these are the petitioners who are working in different capacity in the foreigners tribunal court, fast track court, Lordship, and then they were placed in different branches of the different lower court position. Lordship, there is a review petition, Lordship, at page 68, Lordship. And the effective part of the order is at page 71.
Page
71. So 70, Lordship, page 70. At the bottom, Lordship. And on 16/12/2016, for the amicable settlement of their dispute, the learned senior additional advocate general made the following offer: that their service will not be dispensed with, but for disciplinary action till they attain the age of superannuation, that they will be paid wages minimum of the regular pay scale. Third, that at the time of superannuation, they will be bought under medical insurance scheme. The learned senior counsel appearing for the above named 8 petitioners had agreed to condition number 1 and 2 and the offer of settlement. We therefore regard to the acceptance of condition number 1 and 2 of the offer of settlement, direct the state government as under that the service of the 8 petitioner mentioned above will not be dispensed with, but for disciplinary action by the state government till they attain the age of superannuation, and that they will be paid minimum wages of the regular pay scale from the March 2017 onward. And Lordship, thereafter we were being paid the wages minimum scale along with the allowances. However, thereafter what happened? They stopped our allowances, and therefore they stopped the allowances, and therefore we filed a writ petition before the honorable court. And the judgment of this honorable court is at page 150, Lordship. Whereas
page number
150. The finding is at page 19 and at page 20, Lordship. That is the case of Jagjit Singh cannot have a universal application in this case, as a case in hand has checkered history wherein the writ petitioner was dismissed at the first instance and the matter was reopened only after observation.
See, Mr. Counsel.
Yes, Lordship.
The question is that your entry itself was illegal.
No, Lordship. Our entry was not
It
illegal.
was without any procedure.
Yes, it was as per the procedure, Lordship. The interview happened, everything happened, then only we were selected, Lordship.
But for what? The advertisement provides for what? Permanent job?
No advertisement, Lordship, for that, Lord, the advertisement was there for fast track court employees. Thereafter, we had a writ petition here for the regularization against that post. But as our writ petition was not heard properly, we went to the Supreme Court. The Supreme Court gave us a leave for a liberty to file a review petition.
Now,
And as for
in
this review
review, you compromise the matter.
Now, in review, Lordship, our only prayer is that we should be paid the minimum scale along with the allowances.
No, along with the allowances you get from where?
Lordship,
Along with allowances you get from where?
Lordship, as per the judgment itself, we will be paid wages minimum of the regular pay scale.
Where do you read?
Lordship, pay 71.
That is what we are asking you.
Yes, Lordship.
They shall be paid minimum wages of regular pay scale
Yes, Lordship.
from March so and so.
Yes, Lordship. So we have not been getting our allowances with regard to that.
Allowances is different and scale is different.
Lordship, as per the Jagjit Singh judgment of 2017 judgment and as per the Upenda judgment of this honorable court, Lordship, the minimum scale would inclusive allowances. And as per the pension code, Lordship, as per the definition of salary and wages, they both contain allowances, Lordship. Lordship may refer to I may refer it to it, Lordship.
Mr. Das, what is your say?
My case is very limited. That is para 16 of the impugned judgment, my lord. Otherwise, finance is the main party. Para 16 was the stand taken. And para 18 also, my lord, you have a look.
That is what we were telling you.
Exactly.
That ultimately it is
cannot go beyond
a
page
compromise.
71.
Lordship.
Because if you want to back out from the compromise, then the other side also should be permitted to.
No, Lordship, we were getting our allowances.
No.
Yes.
See, any wrong payment does not mean that your right is created.
No, Lordship, Lordship, in fact, Lordship may.
You have agreed before the division bench and now you want to have further benefit. That can't be granted.
No, Lordship, Lordship may just kindly look at page 117, Lordship. This is an affidavit. This is as the office memorandum 117, Lordship. That the following year hereby notify for all government, state government as applicable for master role workers and similarly placed employees who were appointed prior to FRBDM 1st September 2005, minimum pay scale of 12,000 plus so-and-so plus grade pay, medical allowances, DNS allowances, house rent allowances, as per state government norms, ROP will be admissible. And this is adherence to the Honorable High Court Order 8 June in Writ Appeal 45 to the State of Assam, Mr. Upendas. Where Lordship, the minimum pay scale as defined in my judgment also, it is similar, Lordship. And in fact, Lordship.
Who appears for the government?
I'm appearing, but Lordship, my problem is this item because my name is not showing in the cause list. Just now somebody informed me.
You have to find out a way out in this.
Lordship, can you direct the registry to reflect my name on the text?
For that you have to file your wakalat now. Appearance has to be filed. Appearance can't be by an order.
Then Lordship will fix a fixed date, Lordship, on next date I'll remember.
No, you file your wakalat now. You can't file wakalat now.
I'm appearing for the government law.
But some appearance note has to be filed.
Lordship.
We'll record your name.
Whatever I'm appearing for finance department. Lordship, I will file Lordship. No.
So finance department, you can't file appearance note?
Lordship, file.
Or you can?
We can, Lord.
Then.
Lordship, before Lordship passes away with the recall, Lordship, I just want to point out one thing that would be helpful for the case, Lordship. At page 142, Lordship, before the final judgment had come out, they had given us a page 142 main Lordship main.
Because Mr. Nayak, the fact remains that after the compromise which was recorded in the order, government did pay allowances.
But subsequently we realized that the fault.
No, subsequently you realized on what basis?
But if we give them all the allowances just like a regular employee lordship, there will be no difference between him and other.
No, there has to be a difference.
Lord.
Your minimum pay scale has to be kept minimum only.
It is kept minimum, Lord.
Then there has to be a difference.
Lordship, we are following that now, Lord. That minimum pay scale was there earlier also, Lord.
But pay scale includes allowances also.
Yes, DNS allowance we have given them.
Allowances are included in the pay scale.
But he is claiming for other allowances also, just like an ordinary government employee.
Lordship, I'm asking only for the allowances that is as admissible as per the Rule 9 of the Assam Pension Code, where salary and wages are defined, and there whatever the allowances they are getting. In fact, for Lordship, I would like for that aspect, Lordship, I would like to point out page 142, Lordship, just
That is not binding on division bench. Don't show that order.
No, Lordship, that is because
It is not binding.
Lordship, I understand that. But there was a decision that had to be taken by the state.
That is what we are reminding Mr. Nayak. Otherwise, learned single judge order is never binding on division bench.
Absolutely, Lordship. But
Then we are dealing with an appeal. That may be by way of grace that the learned single judge must have said something. Yes, we are asking Mr. Nayak to find out a way out.
Not.
Find out some way out. Because you started paying them.
Initially, we paid them. Initially, we paid them. But when you realize that there remains no distinction between him and a general ordinary government employee,
That element of difference is not to be considered by the government when you agreed before the court.
no, we are paying as far as we have undertook for this honorable court, Lord.
You undertook for minimum pay scale.
Yes, Lord.
So automatically there will be difference between regular employee and them.
Right now, we are paying them the minimum pay scale, Lord. He is claiming for
Now,
allowance.
what is the pay scale of the regular?
Lordship, it will be the basic pay plus the grade pay. That will be the minimum of the pay scale.
That much I know.
Lordship.
I mean rupees I am asking.
In rupees, Lordship, it will be around 20, including everything, it will be around 20 to 23,000.
And what is the pay scale of regular?
Lordship, in that case, Lordship, other allowances will come in, Lordship.
Allowances is additional. I am on the pay scale.
No, in this case, Lordship, Honorable Court directed to give him the minimum of the pay scale.
Mr. Nayak,
We are
please don't repeat it. We have read it twice, thrice.
We are paying minimum of the pay scale.
You are not answering, or rather we are not clear
Lordship,
on
this is
what we
minimum
want.
is 5200, I think, Lordship, plus grade pay is around 3,900.
We are not on that.
Okay.
You want to compare it with regular person who is in service, maybe in the same organization.
Lordship.
He must be getting different pay scale. It can't freeze at 5,200.
Lordship.
Then automatically the difference would be there. Minimum pay scale means their pay scale is not to be revised.
Lordship, in my affidavit, in my file, Lordship, it is clearly, I have done nothing. Lordship. Today, my problem will be, I am not having the pay.
Try to work out something on this. When you have agreed before a division bench, now you want to argue to the contrary.
No, whatever we undertook before the division bench, Lordship, we are paying that. Lordship, I will
Please
satisfy
don't
you.
give reply as if you are a government advocate only. When something is falling from the court.
Lordship, I will satisfy you, Lordship. On the next day, Lordship will give me a big days, Lordship. I will remember that.
We understand that pay scale also includes allowances also. And
No,
your understanding
no,
was
he
that.
is relying upon Jagdish Singh judgment, Lordship. Before the learned single judge, I was also relying upon Jagdish Singh, Lordship. Here in Jagdish Singh, Lordship, it was clearly told that he is entitled to minimum of the pay scale, but not even DNS allowance, Lordship. Jagdish Singh, Lord.
Therefore, you find out the way out so that if anything can be worked out.
No, our problem will be, Lordship, he cannot be distinguished. He is not the only one, Lordship. As so far as going by the offender's judgment, Lordship, we are paying minimum of the pay scale to more than 1,000 employees, Lordship. If we distinguish him, it will get another, it will open another Pandora's box for us.
Then you should not have agreed before the learned division bench. Why did you agree for this?
No, that is what I'm submitting.
You make a ambiguous statement and then all these problems arise.
No, before the honorable division bench lordship, we undertook to pay him minimum the pay scale.
You work out something if you can. Ultimately, what allowances you pay? It's not a bounty.
I will satisfy your lordship on the nature.
It's not a bounty. His pay scale is never going to be increased till
No, whenever the pay scale is revised, lordship, he will get the revised pay scale.
we
It is
never-
clearly mentioned.
No, Lordship.
He may not get increments, lordship, but whenever pay scale will be revised, lordship, he will get the revised pay scale because that pay scale will change. Today it is minimum is 5,200 lordship.
That is what
Tomorrow, next pay scale, next ROP lordship, it will be revised lordship. Then he will get the revised pay scale.
After 10 years.
It may not be lordship.
After 10 years.
Not 10 years, lordship. Earlier ROP was in 2010 lordship, next one was 2017.
It is virtually 10 years. You are not in service, therefore you don't have the impact of it.
Lordship will see all the judgments, lordship. This case is going on. since
Sir, we are
2010.
conscious about the judgment. We are trying to find out a way out.
Lordship.
Why government feels shy of even telling the court that we'll at least think over it? We fail to understand this type of stand by the government. Nobody compelled you to agree before the division bench earlier. You
Lordship,
should have made it clear before the division bench that virtually they are converted into fixed pay.
I apologize, lordship. That is why I'm repeating, lordship. Whatever we undertook before the learned division bench, lordship, we are paying that. That is our understanding, lordship. And I would like to satisfy your lordship in that regard, lordship, on the nature.
You satisfy us. If we are satisfied, we are with you. If we are not satisfied, we are with him.
Lordship. It's open for you.
But still, however, instead of satisfying ourselves, we want that if it can be amicably put an end. There the resistance is there which pinches us. You are first the officer of the court and then the counsel for the finance department. Don't behave like your secretary. That first blush, everything has to be said no. That is the tendency of finance. Anywhere you go. They don't agree at the first instance, Mr. Nayak. You have been defending them since long, so I need not tell you more.
No, in this case, I am since 2010, Lord.
That is what I am saying. We have seen the record.
Lord.
So you may be correct. We don't say for a moment it is open.
Lord.
We are not on merit. But if anything can be worked out, we can put an end to the control. Please put it through. So you satisfy us. Either way. When do you want?
Lordship will fix this matter in the month of December, Lord.
So you tell us the date. Now we are only 1 month.
On 14th, Lordship?
Huh?
14th.
14th. Let him take instructions, counsel. If anything can be worked out.
Obliged.
Next.
Number 51.
Termination from service, my lord. During the pendency of the case, my lord, in the earlier part, my lord, when I filed one repetition for salaries, etc., my lord, and regarding modification of my transfer order, during the pendency of the case, my lord, 3 years thereafter, my lord, I have come to know that one termination letter has been issued to me. That's why my first round of litigation, I withdrew it. Repetition, my lord, and thereafter, my lord, this repetition filed, my lord. Here, my lord, in this case, my lord, second round of repetition, my lord, honorable single judge, my lord, observed that, my lord, the state there is not any infirmity in the said termination order. Otherwise, my lord, it was not properly served, my lord. One line, my lord, termination order only.
It has to be. Why do you need an elaborator? You were a professional?
No, chief.
You were on probation?
Yes, my lord.
You were on probation?
Oh, no, my lord. He was on contractual employee, he was. my lord.
Then your contract was for how much period?
That was enhanced, my lord. Other, my colleagues are already been, my lord, continued, my lord. Even continuation other, my lord. This is, my lord, regarding the, my lord, post of, my lord, malaria disease, my lord. Malaria technical supervisor. Malaria cannot be in, my lord. And this National Vector-Borne Disease Control Program. is
Now
also-
read para 16 of the judgment.
Lordship. A proposition of law relied upon the petitioner rendered in Ikram Ali Hazarika would also not applicable in the facts of the present case, inasmuch as the matter of Ikram Ali Hazarika, the issue was that a contractual employee was terminated from service on the allegation of unsatisfactory performance. In the said case, the contractual employee therein continued to render his service, but on the assessment of the authorities, his services were satisfactory. In these circumstances, there was no requirement laid down that an opportunity of hearing would be required. But here in this case,
You please read further. Please
Yes,
read
ma'am.
further.
yes, my lord. The proposition of the law relied upon by the petitioner rendered in Ikram Ali Hazarika would also not be applicable in the facts of the present case, inasmuch as in the matter in Ikram Ali Hazarika, the issue was that a contractual employee was terminated from service on allegation of unsatisfactory performance. In the said case, the contractual employee therein continued to render his service, but on the assessment of the authorities, his services were not satisfactory. In these circumstances, there was a requirement laid down that an opportunity of hearing would be required.
Read further. 17 is your finding.
Yes, but in that instant case, it is not allegation against the petitioner that his performance is unsatisfactory. Whereas, as on the other hand, the factual matrix shows that it is a case where petitioner did not attend his duties, and hence it is a case of no performance at all. As the petitioner is unable to put forth by any circumstances or reason that he had in fact continued with his service and not abandoned, we are of the view that even the law of natural justice requiring an opportunity of hearing be given may not be applicable, inasmuch as the law of natural justice is not a straitjacket formula, but would be circumstantial in nature, where the person aggrieved would have to show that by not being given an opportunity of hearing, some kind of prejudice has caused him. No such circumstances is discernible in the present petition. As regards the proposition of relied upon Mr. Das, council.
That is on a different count.
Yes, my lord. Here, my lord, in this case, my
Therefore,
lord.
if you don't work, where is the question of hearing you?
No, I was working there, my lord, because of the discrepancies, my lord, because of the my lord, threatening by the my lord extremists in the area of my lord.
Who would believe that in 2022? These are all lame excuses.
Otherwise, my lord, I have submitted petition also, my lord, before the authority, my lord, regarding my transfer to any safer place, my lord.
You didn't. You wanted to so on your condition. You forgot that you are a servant of somebody.
Yes, my lord. No, I have submitted representation, my lord, regarding my
Representation does not create any right in your favor. Anything else?
Well, otherwise, my lord, as he has not been given notices, my lord, regarding
Anything else than what you have argued?
But my only ground is that my sole ground is that, my lord, as I did not inform regarding the termination letter. So one chance may be given, my lord, and termination from service is a serious, my lord. It is almost finished, my lord, finished his job, my lord.
So two grounds, no notice.
Yes, my lord. No notice was served upon me, my lord. Only this, my lord, letter was issued and kept it in the file, my lord.
An order not communicated. Two
Not
grounds.
communicated, my lord.
Two grounds.
Yes, my lord.
Heard Mr. H. Das.
And I have the judgment also, my lord. I have brought it. There is a division bench judgment also, my lord. It was of this honorable court. And another, my lord, here it is specifically mentioned. My lord, giving one termination letter and keeping it in the file in the office is not sufficient. It must
You can rely upon
Yes, my lord.
Give it to us.
Yes, my lord, I am giving.
For order. Next.
Matter number 52.
Your lordship fix it.
No, it is for orders now. Hold and for order. Judgment will be declared. Next.
But I am appearing for the petitioner. My lord, the respondent.
Who appears for the respondent?
My lord, I was informed that the counsel for the respondent is important number 3. May I pray for A2, my lord, if lordship to address the argument.
Huh?
Subject to lordship permission. To take up the matter at 2 p.m. Second half, lordship finds.
No, we don't mind keeping it at second half. Are you ready?
Lordship, here in this case, lordship be appearing. Just have to take instruction.
You inquire and tell us. Council may not wait till 2 o'clock.
My lord, we have taken the consent yesterday whether my friend will be available. He said she will be available. Therefore, we come from Shell.
No, she said that learned advocate general appear. You inquire and tell us. So that the council may not have to wait. That is why. You come from Shillong?
From Shillong.
Any other matter is there?
As it's been his thought, they can copy their argument, lordship, and he will reply in tomorrow.
We don't allow piecemeal hearing in any. This is not such a matter. This is a virus matter. We have to hear in total. If it is not convenient to him, we may postpone the hearing. We are not in a hurry. Tomorrow it won't be possible because he comes from Meghalaya.
Lordship, yes. You talk to Ms. Patak?
It's not
Okay.
informed that she is available to argue the case. Earlier, learned AG appeared. And subsequently, it informed that she is no longer appear. Other counsel is the case. Therefore, we obtained.
So she says that learned advocate general is.
Lordship, yes, dear lordship, because they have notification, they have challenged lordship.
MS Kotoki, she earlier occasion she appeared. Yesterday, just now I have talked to her. He is in court number 3. She will come in.
No, colleagues of learned advocate general are there. Learned AG appears in this matter or it doesn't appear?
No matter. But this is person difficult, but it only for it. Talking with these fix the matter next.
On Tuesday, the big talk continue.
Which date?
Tuesday. Coming Tuesday.
Next Tuesday.
Next Tuesday. That is 7.
7. Next Tuesday would be 6.
On 6.
6.
6 is Monday.
No.
No, 6.
6.
Okay.
Keep locked.
Yeah.
much of it.
But you don't trade in Assam.
My lord, we are, my lord,
Your clients do not trade in Assam.
my lord, there is no trade in Assam. What they do is that they obtain from the West Bengal with permission valid license, kept in the animal market in Meghalaya via Assam. Only the transit point, my lord, is my lord, the egg is applied. The egg with the lane is applicable here, and that's created some problem with the.
And what is the requirement of the act?
My lord, now the requirement of the act is that I have to obtain the permits under the Cattle Conservation Act 2021 only for three purposes. Two purposes. One is for the bona fide agricultural purpose, and second is animal husband. My lord. Now, knowing very well that, my lord, I'm not engaging in this, but engaging in the trade, my lord. Therefore, my lord, we put up the application, but they rejected. Subsequently, before rejection of my application, there was an amendment of the very act, and government has inserted the word trade, the transportation of cattle for trade, the vast scope. My business fall under this category. My application ought to be considered in this category, but they have rejected my application, saying that your application is not for the bona fide agriculture or for deal.
That is what we have noticed that fact. So ultimately, your challenge to the virus, because we can ask the learned advocate general to you apply again for trade and they will consider it.
But not the
otherwise it's a reasonable restriction.
My lord, they have taken the plea in the affidavit. Had they have taken that plea in the rejection order, I could have put up the fresh application mentioning the trade.
That
is the impunge order. They have just simply rejected that it is not.
No, you forget the rejection. The question is that the law is amended, which you have challenged. Ultimately, it's a reasonable restriction. They don't prevent you.
My lord, there is a prevention in the coming week. If lordship the learning advocate to come forward that I can apply, I'm ready to apply with mentioning the purpose of.
Because ultimately it is reasonable restriction.
I will apply. My lord,
they want to see that the business is real business.
My lord.
You also think it over. This is food for the food for thought of learned advocate general. Two juniors are there.
Yes.
You convey it to learned advocate general.
Yeah.
Ultimately, it will boil down to this only. I allowed. Now only one request.
My lord.
There are two requests, in fact, because I don't consider you to be an adversary.
No, certainly.
Not at all. You take it from me that notice is where. In fact, I may tell you, I did not, they issued a notice. I did not approve that draft. So it was done second time.
Okay.
There might be some miscommunication here. Also. You are implicated as a party. You please go through inspect the original file and go through the orders that we have passed from time to time. One thing. And myself, my brother, one of the senior judge, Mr. Das, Mr. Nath, Mr. Kanwar, learned advocate general, we all had visited the site. I don't mind repeating that in your presence. We have to find out some way out.
My lord.
There are certain issues which are beyond this. Otherwise,
my lord, if it can be addressed, why not? That is my humble submission. If it can be.
And I may tell you that we explored all possibilities. Once I am not mentioning it because I have to deal with it on judicial side. You please have a look at the file.
I'll go through all the order sheets and all, my lord.
Please go through it.
Yes.
What attempts have been made by the bench to see that this is resolved? All attempts.
My lord. My lord can have them. My lord can have the matter on next week, my lord.
I may tell you one thing. We involved IIT Guwahati.
Yes.
We involved BRO. Everywhere we have gone. In fact, Kanwar, at one point of time, I could make out from this chair that he was little annoyed with the stand taken by us. But still ever, it is not an advisory. We know this. We have
My
been-
lordship, now, the work has been stopped. So,
Maybe we'll try to resolve it
Lordship.
if we can.
lordship. After you can let go. Lordship.
My lord, in fact, we could lay our hands to a map prepared by the Revenue Authority, which clearly shows the existence of road mine.
You don't come to any conclusion without looking at.
What I'll do, my lord, I'll go through all the order sheets.
Please go through
Lordship will
it
kindly give me 7 days time. Let the matter be called after 7 days. The Lordship will take a call.
Tuesday.
Tuesday, nothing.
When are you coming back?
My lord, hopefully I'll come back on Thursday, my lord. Lordships can have it on 11th if it is not inconvenient, my lord.
11th is a Sunday.
No, my lord, December.
December.
I'm sorry. Huh? I'm sorry. Huh? Uh-huh.
11. No,
Or 12th, my lord. It can, 12th,
So you are going to Supreme Court when?
actually, my lord, my matter is being taken up on 6th. One matter on 6th, one matter on 13th.
Huh.
So 6th matter, even if it continues, I think Lordship can keep it on Friday, 9th, my lord.
9.
Yes.
But please make it a point that on Friday itself we may go and visit.
Yes. We are prepared. my lord.
Mr. Nath.
Lordship.
Mr. Das.
Lordship,
We may visit it on Friday after the hearing.
this Friday,
No,
Next Friday.
Next Friday,
Nine. 9.
next Friday. Lordship.
Or if the Chaudhary is available, we can go on Monday.
My lord, if the matter does not progress beyond 6th, I'll come back on 6th itself.
No, are you
No,
available?
one
on
thing
fifth?
can be done, my lord, if the matter is taken up on 9th,
Huh.
if a day prior to 9th, the visit
No,
can
no.
be.
Are you available on 5th?
5th, no, my lord. I'm going on 4th, my lord.
You are going on 4th.
Second half.
I am not available. Can we go tomorrow?
Yes.
Lordship.
Sometime talk or after. Yes, yes. We can go, my lord. I have no problem.
I have a meeting at 4:30, so either after that or before that.
Okay, now. Oh, recess time, we can go. 1 o'clock. Okay.
Yes. No, tomorrow recess won't be possible for me.
Oh. We can take a chance day after tomorrow also, my lord.
I am not available.
No. Okay, take it nice. No.
We can go at 3 o'clock.
Tomorrow, my lord.
Huh.
Yes, I have no problem. I'm ready, man.
I'll put it to my senior brother also.
Well.
To make it convenient.
Yes.
3 or 3:30.
Oh, no problem.
Because we will have to be back. Right?
Yes.
Because
Lordship.
we want to resolve this. You can talk to Mr.
Yes,
Chaudhary
yes.
about-
I'll have a talk with my senior.
Next.
Deep.
I leave.
Number 25.
Yes.
Please, my lord, I beg apology at the first discuss, my lord, I was not there in the first of my lord.
No problem.
My lord.
Tell me what are your instructions?
Here, my lord, my submission subject to what my lord interprets and finds, my lord. So there is no duty casted on the deputy commissioner and the appellant, my lord, the commissioner and secretary of the revenue department, my lord, to take care of the land, my lord, which was damaged by the, my lord, National Games Authority way back in the year 2005.
Counsel, you should take a pragmatic view. When you want to hold national games here, you give big advertisement.
My lord.
And when it comes to you damage somebody's property, you have to make it good.
Absolutely no quarrel, no difficulty. But my lord, my submission is, my lord, I am representing the two authorities, my lord, the commissioner and secretary revenue department and the deputy commissioner Kamrup Metro, whom my lord, the learned single judge has given the direction, my lord, either to make available alternative plot of land or to pay compensation. Now, my lord, I am putting a question to myself. I have not hold, we are the two authorities, we have not conducted the national games. And
No,
my
no,
lord,
that is not also absolutely true. it is through your patronage that the national games are held. For example, one day international was held. Can Assam Cricket Association say that we were not involved? Can BCCI say that we were not involved?
Malad, that is one way of looking into the matter. Malad, my
That's the
respect-
only way of
Malad.
looking at the matter.
And Malad, the statement.
You give government gives big boost advertisement for holding national games, and then when you damage somebody's property, where will he go?
That is true. Here, my lord, here, Lordship will
Find out a way out.
Yes, Lordship will kindly consider.
We don't say that you give him a plot, but at least you have to do something.
Restore either, my lord, we can take steps, my lord.
You instead of paying compensation, because this is not a matter of earning for it. But at least, for example, if it is not properly leveled because it is used,
Yes, that
pits
much,
are there.
Yes, absolutely, I take it.
Then you have to make it as it existed when you started making use for the national game.
My lord.
Who has utilized the land?
My lord, the National Game Secretary.
No.
My lord.
You organize at the instance of National Game Secretariat.
My lord.
Provided the land.
Who provided the land?
My lord, here the admitted position.
Under whose orders the lands were given to National Games Authority?
My lord,
Easy.
Yes, Deputy Commissioner, my lord, we have, my lord, acquired the land. But
That is
my
what
lord,
we are saying.
No, my lord, will kindly consider, here lies a distinction. My lord, we had, in the affidavit filed before the learned single judge, there is a categorical stand, my lord, that the land belonging to the petitioner, the land in question, it was neither requisition nor acquired.
Maybe,
So
but
therefore,
you have used it.
My lord, we haven't used it, my lord, it is the national game.
Who passed an order? Then you go, it is just like MSCT matter.
My lord.
Pay and recover. Why should the citizens suffer because of your plazas?
That I can understand, but my lord, since there is no duty.
You recover it from anybody, including central government. The citizen whose land is utilized, you say it is not requisite, it was not acquired, not, at least you requisite that land.
No.
Then वो उसने सामने से आके दे दिया.
No, my lord, because the adjacent lands were requisition, and while my lord, they digging up those lands, the National Games authorities at that point of time, they also continuously, my lord, encroach into the petitioner's land.
It can be seen now after so many years.
That's it, my lord.
You have to make good. You level the land and give it. You at least pay for the leveling. If not compensation.
Yes, lots of me direct in that way, my lord. Because my lord, these two appellants are agreed, my lord, by the strict direction given by the learned single judge, either to pay compensation and to provide, my lord, alternative. Lordship is well aware, my lord, in the city of Guwahati, it is very difficult.
You do one thing, you get that land verified through your office.
My lord.
The TC.
My lord.
That's the status.
As on today.
As on.
My lord.
The land is available or it is still under water.
My lord.
Find out.
My lord.
And then you take the.
You restore it back to the original position.
Yes, by filling up.
At least that much, that liability you have.
Yes, that definitely. Because Lordship will kindly appreciate, my lord, that two pictures that has been given by the learned single judge, my lord, to
You forget that.
You forget that. In order to obtain that, you should have already done for a verification.
Next week.
My lord, Lordship will kindly give me 2 weeks.
No, it is here. Even today, you can go and have a photograph in your mobile.
My lord, I have some personal difficulty next week, my lord. Kindly, my lord.
Ask your doctor TC to do it.
My lord.
Just he is some doctor, isn't it?
My lord, Pallab Gopal sir.
Doctor.
My lord, Dr.
I read in the newspaper his name, therefore I knew it.
My lord.
Do it.
My lord.
Today's newspaper only.